All right, let's proceed.
Your Honor, before we get into actually the merits of the motion, I want to make sure that everybody's looking at the same thing as I took a peek at the docket earlier today. The defendants have two pending objections and motions to dismiss, one for each of their respective expert reports that were served by plaintiff. On the court's docket, however, I think it just had one included in the online docket, so I just wanted to make sure that Your Honor had access to both motions that were set to be heard.
I've only read one, so I don't know what the other one's about.
Well, hopefully you read the more important one, but we'll get through that together. So I'll just go ahead and give you kind of a background and a summary of the two motions that are pending.
Okay.
As I stated, plaintiff has served two separate Chapter 74 expert reports in this case, as related to the acts or omissions related to Presbyterian Village North, or PVN, as you may hear me call them, and their nursing staff. The first report that was served was from Dr. Edward Eden, and defendant timely filed an objection to that one and moved to dismiss based on the fact that it was conclusory in nature. There was a second report that was authored by nurse Stacy Donnelly, and that one was objected to by PVN based on the fact that it was served untimely, that Ms. Donnelly was not qualified to give the opinions that she did, and then also that her opinions were conclusory in nature. So for those reasons, defendant objected to both of those reports and moved to dismiss. So a little bit of factual background. I think those are, the facts are kind of summed up in the motions and the response, but just very briefly, Mr. Lewis was the decedent in this matter. He was 84 at the time and admitted to PVN with a history of hallucinations, acute and chronic respiratory failure, lung disease, pulmonary fibrosis. He was admitted to our skilled nursing facility on January 21, 2019. And he was discharged from Presby, the hospital, after having been there for several days, and was under PVN's care until January 31, 2019. At that point, he was found unresponsive and sent back to the hospital. And then 2 days later, he died. So 2 days later, while he's under the care of the hospital and no longer under the care of PVN, is when he actually expires. Interestingly, and this is part of the reason we find both of these reports to be conclusory, is that neither report actually addresses the immediate cause of death. They just frankly say 2 days later, on February 3rd, 2019, Mr. Lewis passed away. And there's nothing to indicate what the actual cause of death was at the time. So that's kind of where we're starting from. As for, I'm sorry, did you?
Go ahead.
Okay, so as for just some procedural background, there's no objection to Dr. Eden's report on the timeliness issue. Nurse Donnelly's report was served more than 40 days after the expiration of the deadline to do so. So that one I think might be the simplest report and the simplest objections, giving the untimeliness of its service. And then also there's one more kind of procedural issue to address before we dive into the merits of the motion and the objections, is that plaintiff has only filed a response to the objections and motion to dismiss with regard to Dr. Eden's report. And there was no response related to the motion and objections for Nurse Donnelly's report. Furthermore, it was only filed, plaintiff's response was filed Thursday after hours. So essentially Friday, one day before the hearing set for today. So based on Local Rule 209, we'd ask that the court not consider their response in considering the motions today. Any questions before we jump into the Chapter 74 issues? Judges, you're aware, the Chapter 74 requirements ask for a fair summary of the applicable standard of care from an expert before a plaintiff is able to move forward with their medical malpractice claim. It also asks for an explanation of the manner in which the care rendered by the healthcare provider failed to meet a specified standard of care. And lastly, and importantly, the causal relationship between that failure, that act or omission, and the injury complained of, in this case, a death. The only relevant information for Your Honor to consider is within the four corners of those reports, assuming we even get to that with Nurse Donnelly. And the court, in considering the sufficiency of these reports, is precluded from filling the gaps, from filling any inferential gaps in the report and drawing inferences or guessing what the expert meant or was intending to say. And that is pulled from the Palacios case and the Wright cases.
Ms. Richardson, why don't we just kind of get to the, what is the real meat of what you're trying to do? You don't have to just read the briefing again.
The meat of it is Dr. Eden's report as to PVN. The standard of care that he opines is to properly screen patients at intake. He says that that PVN breached that standard by, one, admitting a patient without proper preparation, staffing, training, and procedures, but does not say what preparation that was, whether increased staff or different staff would have changed anything, and what additional training or procedures would have prevented Mr. Lewis's death. Now, I said at the top of the hearing that the immediate cause of Mr. Lewis's death is never mentioned in either of these reports. So we're starting with a missing link. The purpose of this expert report is to establish the causal link from the conduct complained of to the injury, in this case, a death. We're missing even that last link from these reports. So we can talk about causation also, but we don't even know what these experts are saying was the actual cause, the immediate cause of Mr. Lewis's death. So we don't even have anything to work backwards from. So another breach that Dr. Eden points out or offers in his opinion is failing to provide a level of care necessary for Mr. Lewis's condition. That level of care he describes is constant care by a respiratory therapist. But we have established case law out of El Paso, at least, that says that that's not enough. What has Dr. Eden said anywhere in his report to suggest that more staff or constant staff or somebody being there 10 hours instead of 8 hours would have prevented the injury, and in this case, a death? Last, the standard of care breach that Dr. Eden refers to as inadequate training. And what he points to in his report is the fact that PVN's nursing staff underwent approximately 2.5 hours of training related to BiPAP care and machine application and things like that. But at no point in the report says that that training was improper, inadequate, insufficient. He just says that nurses spent 2.5 hours being trained on how to place the mask, how to give a nebulizer treatment, and how to connect the oxygen machine. There's nothing that says that that was wrong. There's nothing that says that that training was supplemental or not, or that that training led to Mr. Lewis's death. So those are the three kind of big ticket items with Dr. Eden's report that show that it's conclusory. We're missing that final link, and we're missing the causative link.
Ms. Martin, response?
Sure thing. If I may, Your Honor, first respond to kind of the preliminary issues that Ms. Richardson brought up. The Runnels report that she had mentioned, it was not intended to opine as to Defendant Presbyterian Village North. In the opinion, it states that it was meant to be as to Defendant Reynolds, who has since been dismissed. And so that report, we were not intending for that to be an opinion as to Presbyterian Village North at this hearing, which is why we did not include it in our response. Another quick issue that I think is worth noting, when we filed our response, I had correspondence with Ms. Richardson's associate. We had clarified a lot of the issues in these motions and the objections to try to get to the root of the issue, and actually non-suited a few of the individual defendants to try to streamline things as much as we could today. So I had reached an agreement with her to file our response the next day so that we could change it to address the most updated defendants. But that being said, in regards to Dr. Eden's report, I'm sure, as you know, these reports are really just meant to be very baseline. It's a good faith effort, and they are meant to deter frivolous lawsuits and frivolous claims. And the Supreme Court.
I was around. I did personal injury back when these things were passed. I understand what they're here for.
Excellent. Well, I think the crux of the issue here is that Dr. Eden sets forth exactly what happened as far as a timeline of events that happened and which actors did the events, and it sets forth Mr. Lewis's deteriorating condition, which ultimately leads in his CO2 narcosis and death. And so his report goes through how Presbyterian Village North and its employees have breached the standard of care over a 3-day period, starting with failure to train, to have the adequate supplies, to adequately screen patients, which then leads to him not receiving the correct oxygen levels or BiPAP, which were against the doctor's orders from the hospital that had discharged him. It goes on to say that his oxygen tubing was disconnected, his mask was ill-fitting, there was not a respiratory therapist available to treat him, and that led to low blood pressure, altered mental status, and then it also gets into the doctor's failure to act on the deteriorating condition and leads him to be unresponsive, have low oxygen level, and then CO2 narcosis and death. So taken together, I think when you look at the report and the way that Dr. Eden has provided support in factual support for his opinions as to the standard of care and to causation, that this report is more than adequate to meet the low threshold of the Chapter 74 expert report.
The objection to Dr. Eden's report is, I guess, the motion. I guess motion is the objection to the report is denied.
Objection overruled and motion denied.
Yeah, that sounds good.
At the end of the day, we just want to make sure our order says what it needs to say.
No, that's exactly right.
Okay, just 1 second.
All right, what's the next one, Ms. Richardson?
The next one has to do with Nurse Donnelly's report. And
let me just say, Mr. Reynolds, I'm not trying to keep you out of this, but if you as I understand, you don't have a dog in this fight.
I do not have a motion pending. You're right, Your Honor. I do not.
Okay. Go ahead. So if you want to speak up, but I'm not.
I understand. Sure.
Go ahead, Ms. Richardson.
With Nurse Donnelly's report, and perhaps Ms. Martin gave a little bit of insight of why it even exists and why there is a second report. It does specifically address the conduct of Nurse Runnels, who was the director of nursing at the time of Mr. Lewis's treatment. And so the implications from Nurse Donnelly's report have to do with PVN's employee, their director of nursing, and their nursing staff. So it's the same as if it were directly against PVN. It's the the actions of its nursing staff, which we are responsible for if they were acting in the course and scope, which is why we filed our objections based on the timeliness, her qualifications, and conclusory opinions. And it was actually set for hearing. Now, I understand that Nurse Runnels was individually non-suited kind of midweek last week, along with two of our other staff members, Nurse Smiley and Tony Elder, the respiratory therapist. But it didn't take away the opinions that were offered in this report as to PBN and its nursing staff. We are still potentially responsible for the actions of Nurse Runnels, and this report is criticizing the actions of Nurse Runnels and her nursing staff.
Let me make sure I understand all the parts. So PBN is still in the case, but Reynolds and these other two nurses are not.
Correct.
Or staff members are not.
Correct.
Okay, go ahead.
And so this motion was still pending. There was not really any reason to pull it down. The response that was filed Thursday evening, Friday morning by plaintiff only addresses or responds to the objections to Dr. Eden's report. It's almost moot at this point if the objections are overruled for Dr. Eden, but we do have this outstanding report and the pending objections and the motion to dismiss that we would ask for a ruling on. Nurse Donnelly's report was just simply filed late or served late. It was more than a month past the deadline without really any reason or explanation as to why it wasn't why it wasn't served within the appropriate time frame. But it still is a report that's out there, a report that implicates our employees, and one that we've objected for and moved to dismiss based on.
Response.
I would just say that Nurse Runnels' deadline had not yet passed when we had served that as in her capacity as a defendant. So it was properly served as to her as an individual defendant. And now that she is not an individual offended, I think that report is moot as to her. And now that we have a proper expert report for Dr. Eden as to Presbyterian Village North, plaintiffs do not intend to use the opinions in Nurse Donnelly's Chapter 74 expert report to implicate Nurse Donnelly or Presbyterian Village North.
Right, that motion is granted. All right, anything else, guys?
Not for me, Your Honor.
Let's chat because this is coming up a lot. When is y'all's trial setting on this?
I'm
not sure if we have one. It's far off, Judge. We're just, as you see, we're just now doing Chapter 74 challenges, so we're very, very early on in this case. I'm not sure we even have a trial date.
We do, but it's June 21, 2022.
Okay. Okay. Anything else to talk about, guys?
Your Honor, just for clarification on the order, since it's kind of a half and half, the objection as to Dr. Eden's report is overruled, and the objection to Nurse Donnelly's report is sustained. The motion to dismiss is denied.
Motion dismissed. Yes, I think that's correct. And if you could do this, I should have said this before. If you could, I'm asking people to change the way they do orders slightly. At the beginning, instead of saying on this day, put on January 10th, 2022. It's easier for me to track. We just get so many orders right now, and with it being remote, it's hard to follow. So you could put it's on that date. Ms. Richardson, I assume you're billing by the hour, so I'm going to let you prepare the report, the order. If you could share it with Ms. Martin. Mr. Reynolds, I can't imagine you would need to see it, or unless you want to.
No, I'm good.
He doesn't need to see it. So just share it with Ms. Martin. Once you guys have had a chance to talk about it and make sure the order's okay, go ahead and submit that to the court. If you could e-file it and email it to Rhonda. And then if you could get that to me before Friday. Does that work okay for you, Ms. Richardson?
Yes, sir. I'm just looking at Friday's date so I don't write it down wrong. Okay.
Yeah, or just submit it to me before Friday, but put down today's date on the order.
Yes, sir.
Does that work for you, Ms. Martin?
Yes, sir. Thank you.
Understood.
All right, guys. You guys be safe, and COVID is everywhere right now, so be careful. And I've heard just so many offices are getting shut down right now. It's the worst I've ever seen it. So just be careful out